Welcome to this comprehensive guide designed to help you prepare for your law viva voce. In this video, we'll break down the essentials of the legal profession, focusing on its noble character, ethical foundations, and the practical aspects you need to master. Whether you're a student or a budding advocate, this journey will clarify what makes law a service-oriented profession and how you can confidently approach your viva. Let's start by understanding why law is considered one of the noblest professions and what sets it apart from other careers. Law is not just a trade or a business. It is a service-oriented profession dedicated to the administration of justice. The primary goal of the legal profession is to help litigants and victims secure justice, always placing service before personal profit. Advocates are expected to uphold the highest standards of integrity and fairness, ensuring that justice is accessible to all. This commitment to service over self-interest is what truly makes law a noble calling, respected across society. Professional ethics in law refers to a code of conduct, both written and unwritten, that regulates the behavior of practicing advocates. These ethical guidelines serve as a moral compass, defining what advocates should and should not do in their professional lives. Upholding these standards is crucial for maintaining the honor and dignity of the legal profession. By following ethical norms, advocates ensure that their actions reflect positively on the profession and foster trust in the justice system. Core objectives of professional ethics in law are threefold: maintaining the dignity of the profession, building societal faith in the justice system, and ensuring the smooth and efficient functioning of courts. These objectives guide advocates in their daily conduct and decision-making. By adhering to these principles, advocates not only protect their own reputation, but also contribute to the credibility and effectiveness of the entire legal system. Advocates Act 1961 is the supreme law governing the legal profession in India. This act consolidated previous laws and established a unified bar for the entire country. Structured into 7 chapters and 60 sections, it lays down the framework for the profession, including the creation of the Bar Council of India (BCI) and state bar councils. These bodies are empowered to set the rules for professional conduct and etiquette, ensuring uniform standards across India. Legal profession in India is regulated by a two-tiered system. Enrollment of advocates happens at the state level through state bar councils (SBC), while the Bar Council of India (BCI) sets overall regulation and standards at the national level. This structure ensures that advocates meet consistent qualifications and adhere to professional rules, maintaining the integrity and quality of the legal profession across the country. Be enrolled as an advocate in India, one must meet specific qualifications outlined in Section 24 of the Advocates Act 1961. These include being a citizen of India, having completed the age of 21 years, and holding a law degree from a recognized university. These requirements ensure that only qualified individuals are allowed to practice law, safeguarding the interests of clients and the justice system. Can someone with a foreign law degree practice in India? The answer is yes, but only if their degree is recognized by the Bar Council of India and they receive explicit permission from the BCI. This ensures that all advocates practicing in India meet the same rigorous standards, regardless of where they obtain their legal education. Even if someone meets the basic qualifications, certain conditions can disqualify them from being enrolled as an advocate. These include conviction for an offense involving moral turpitude, conviction under the Untouchability Offenses Act, or dismissal from government employment on similar grounds. However, these disqualifications cease to have effect after 2 years from the date of release or dismissal, offering a path to rehabilitation. Advocates enjoy several exclusive rights and privileges. Section 30 of the Advocates Act grants enrolled advocates the exclusive right to practice before any court, tribunal, or authority in India. This privilege ensures that only qualified professionals represent clients in legal proceedings, maintaining the quality and integrity of legal advocacy. Advocates are granted privilege from arrest under civil process while going to, attending, or returning from court proceedings. This special protection ensures that advocates can perform their duties without undue interference, supporting the smooth functioning of the justice system. Advocates possess significant freedom of speech and expression while presenting their case in court. This right is essential for fearless and effective representation of clients. It allows advocates to argue cases robustly, challenge opposing views, and ensure that all relevant facts and laws are brought before the judge. Advocates have the right to enter the bar, meaning they can become members of bar associations. This membership allows them to participate in the collective life of the profession, access resources, and contribute to the development of legal practice in their region. Advocates have the right to charge a fee for their professional services. This right ensures that legal professionals are fairly compensated for their expertise and time, allowing them to sustain their practice and continue serving the cause of justice. Advocates are expected to be cooperative with colleagues, especially juniors, and to act in a manner that upholds the honorable reputation of the profession. This spirit of cooperation fosters a supportive environment, encourages learning, and strengthens the legal community as a whole. Maintaining a respectful attitude towards the court is a fundamental duty of every advocate. Advocates must uphold the dignity of the court, never mislead it, and always assist in the administration of justice. This respect is crucial for the smooth functioning of the judicial process and for maintaining public confidence in the legal system. Justice system rests on 2 pillars, the bar and the bench. The bar refers to all practicing advocates or attorneys, while the bench refers to all judges and judicial officers. Both play distinct but complementary roles in the administration of justice. Advocates argue cases and represent clients, while judges decide cases and uphold the law. Bar, as officers of the court, present arguments and evidence, while the bench, as the judicial body, decides cases impartially. This division of roles ensures checks and balances within the justice system. Advocates and judges must work together, each respecting the other's responsibilities to achieve fair and effective outcomes. Cordial and respectful relationship between the bar and the bench is essential for the effective administration of justice. Mutual respect and cooperation allow lawyers to assist judges by presenting law and facts clearly, while judges rely on this skilled assistance to deliver fair and informed judgments. Both share the common goal of administering justice efficiently and impartially. Professional misconduct is any act or omission by an advocate that violates the professional rules and ethical standards established by the Bar Council. Such behavior is considered disgraceful or dishonorable by peers, and can include disrespecting the court, misleading clients, misappropriating funds, or betraying confidentiality. Maintaining high ethical standards is essential for the credibility of the legal profession. When an advocate is accused of professional misconduct, the disciplinary committee of the Bar Council, either at the state or BCI level, investigates the complaint and takes appropriate action. This process ensures accountability and upholds the standards of the profession, reinforcing public trust in the legal system. Disciplinary committee can impose three main punishments for professional misconduct: reprimand, suspension, and removal from the role. A reprimand is a formal warning, suspension temporarily revokes the right to practice, and removal from the role disbars the advocate, ending their legal career. These measures ensure that ethical breaches are addressed appropriately. A reprimand is the least severe punishment for professional misconduct. It serves as a formal warning or censure, officially recording the advocate's misconduct. While it does not bar the advocate from practice, it acts as a serious reminder to uphold professional standards. Suspension is a temporary punishment where the advocate is barred from practicing law for a specified period. During this time, they cannot appear in court or represent clients. Suspension serves as a corrective measure, giving advocates a chance to reflect and reform their conduct. Removal from the role is the most severe punishment for professional misconduct. The advocate's name is permanently removed from the state role, effectively disbarring them and ending their legal career. This ensures that only those who uphold the highest ethical standards remain in the profession. Contempt of court refers to any conduct that disobeys a court order or shows disrespect towards the authority, dignity, and administration of justice. It can include acts that scandalize the court, prejudice a fair trial, or obstruct the judicial process. Unlike professional misconduct, contempt is a direct attack on the authority of the judicial system itself. Under the Contempt of Courts Act, 1971, punishment for contempt can include simple imprisonment for up to 6 months, a fine of up to 2,000 rupees, or both. These penalties are designed to uphold the authority of the courts and ensure respect for the judicial process. Contempt of court is divided into civil and criminal contempt. Civil contempt involves willful disobedience to any judgment, order, or direction of the court, typically affecting the rights of a specific party. Criminal contempt includes acts that scandalize the court, interfere with judicial proceedings, or obstruct justice, attacking the integrity of the judicial system as a whole. Examples help clarify the difference. Deliberately refusing to pay a court-ordered settlement is civil contempt, while publishing baseless allegations against a judge is criminal contempt. Both forms undermine the authority of the court, but in different ways, and are dealt with accordingly by the legal system. Wrap up: here's your Viva checklist. Understand the Advocates Act 1961 and its significance. Know the punishments for misconduct: reprimand, suspension, and removal. Remember the Section 24 qualifications, the difference between bar and bench, and the meaning of contempt of court. Be clear on the distinction between civil and criminal contempt, and the roles of the BCI and State Bar Council. Finally, internalize the fourfold duty of advocates to the court, client, opponent, and colleagues. With these concepts, you're ready for your Viva Voce. Welcome to this